The vast increase in workers' compensation claims, civil suits, and medical and legal problems is gradually involving physicians in practically every specialty and field of interest. To a great extent, people in this country have become litigious, like the little 6-year-old boy at school who tripped on the leg of a metal desk as he was going up to write on the blackboard. He fell flat on his face, and the very solicitous teacher rushed up to him and said, "Oh, you poor little dear." At which point the little boy turned around and said, "Poor little dear, heck, somebody's going to get sued." Newspapers dramatize on their front pages startlingly high verdicts which excite the public and the legal profession. In practically every one of such verdicts, physicians have contributed in one form or another, either as expert witnesses, treating physicians, or medical consultants. Unfortunately, medical training in undergraduate and graduate institutions has as yet not prepared physicians to fulfill our responsibilities in this area. It is essential for physicians to acquire the ability that will enable us to perform these tasks with accurate knowledge and confidence, and to avoid apprehension and fear in legal environments. The 4th edition of the American Medical Association's Guides to the Evaluation of Permanent Impairment, known as the Guides, provides the most excellent foundation for physicians in almost all disciplines to perform their responsibilities. Carefully reading chapters 1 and 2 of the guides will make it easier to apply the ensuing chapters for special needs. The purpose of this presentation is to make it easier for you to understand how to apply the guides to our special needs. The first edition was published in 1971, and with each edition the authors improved the chapters, established normative values and tables, answered the most important questions, and included the finest state-of-the-art knowledge about each subject. Dozens of the best scholars, legal practitioners, medics, critics, and countless others have contributed to make the guides the most credible and valid source of information for impairment determination. The guides provides a standard framework and method of analysis for evaluating and reporting information about the impairment of any human organ system. The guides is based on fundamental scientific and medical concepts and judgments of the most knowledgeable clinicians and scholars. The 4th edition should prove extremely helpful for physicians in diagnosing an impairment that can withstand scientific and legal scrutiny. If different physicians use the guides properly, the resulting reports from different physicians in different parts of the country are likely to be comparable in content and completeness. First, let's clarify the difference between 3 commonly used terms: impairment, disability, and handicap, especially that between the first 2. Impairment means alteration of an individual's health status. It is a deviation from normal in a body part or organ system and its functioning. It requires a medical evaluation. Such an evaluation is the responsibility of physicians. We all recognize that normal is really not a fine point or a line. More often it is a zone, such as in vision and hearing, and varies with age, gender, and other factors. Certainly, normalcy is different in a 20-year-old than in a 75-year-old individual. In calculating impairment in each chapter, the authors have taken this variance into account. This allowance makes it much easier for the physician to determine impairment in a standardized manner. Disability is a change in an individual's capacity to meet personal, social, or occupational demands because of impairment. While impairment is a medical matter, disability generally is not. Disability comprises an interaction between impairment and external circumstances, particularly an individual's occupation. In common terms, disability is the gap between what a person can do and what he or she needs or wants to do. Just because an individual has an impairment does not mean that he or she is necessarily disabled. For example, millions of people have slight visual and hearing losses that deviate from normal. Strictly speaking, they can be classified as being impaired. However, most are unaware of their impairment, and certainly they cannot be classified as being disabled. The concept of disabled is closely allied to occupation and job requirements. According to the Guide's concept of handicap, a person with limited functional capacity is handicapped if he or she has an obstacle to accomplishing life's tasks that can only be overcome by using an accommodation device such as crutches, wheelchairs, hearing aids, optical magnifiers, prostheses, and so on. According to the Guides, a person who is not able to accomplish a specific task or activity despite efforts to accommodate him, as with a wheelchair or hearing aid, may be classified as both handicapped and disabled. If an individual can accomplish a specific task with or without an accommodating device, the individual is neither handicapped nor disabled with regard to that task. The definition and concept of these three terms, impairment, disability, and handicap, may differ amongst federal law and the law of the 50 states. These differences should be taken into consideration where the specific problem has arisen. In general, a physician's responsibility is limited to determining the presence or absence of impairment. However, there is increasing demand for the physician, particularly the occupational physician, who understands the patient's needs and job requirements, to express an opinion as to the amount of disability and or handicap that may be present. Many occupational physicians have acquired considerable experience and knowledge and may have the expertise to express meaningful judgments about disabilities and handicaps. The Guides cannot always provide exact answers about every type and degree of impairment. The varieties of human disease are practically infinite. Constant changes occur in medicine and its application. Good judgment, experience, training, and skill in patient examination and applying the findings to the Guide's criteria are important factors in establishing the degree of the patient's impairment. The authors of the various chapters have tried to provide objective data regarding the function of normal persons and organ systems. For some systems, such as respiratory, cardiovascular, visual, and auditory systems, the accepted data on normal functioning have been well established. If such data are not available, the estimated impairments and criteria are based on the best clinical experience, judgment, and consensus of the finest experts in the country. The Guides presents a reasonable estimate of the degree to which an individual's capacity to carry out daily activities has been diminished. The major objective of the Guides is to describe the process of assessing and reporting impairments in accordance with a single set of standards. The result will enable two physicians in different parts of the country to report similar results and conclusions. Any other knowledgeable observer should then be able to check the findings and reach the same conclusions. This system will help obviate different opinions from physicians who do not use a standard method of evaluating and reporting impairments. For example, if the Guides were not utilized, one physician may measure ankle or knee flexion, but another may not mention these movements at all. All physicians who plan to use the Guides should read chapters 1 and 2. By carefully consulting the standard medical evaluation protocols and reference tables, and using the procedures recommended in the Guides, physicians can estimate the patient's percent of impairment. However, this single impairment does not provide much information about the impact of the impairment on the person's capacity to meet personal, social, occupational, or other demands. Much more information is needed. The scope of the physician's documentation required for a comprehensive, reliable report is listed and described in the Report of Medical Evaluation of the Guides. To support the estimate of impairment, permanent impairment, the report should follow the Guide's clear and accurate basic information shown in this chart and found in Chapter 2. On many occasions, physicians are called upon to determine permanent impairment of an individual they have never personally examined. Instead, they receive documents on which to base their opinions. First of all, it is essential to determine the reliability and validity of the information supplied. Often, there will be varying or even diametrically opposite findings, especially between claimants and defense experts. The standard methods in the guides help the evaluator distinguish which findings and opinions seem to be valid and reliable, or the guide's evaluator can request additional examinations. Typical examples of such conflicts occur especially in back injuries, so-called whiplash injuries, and causes of hearing loss. To specify the percentage of permanent impairment, it is important for the evaluator to obtain all the necessary information to characterize the medical condition fully in accordance with the requirements of the guides. If the findings are not consistent or adequate, further investigation should be undertaken. When the evaluator has completed the analysis, the report should include a description of the specific clinical findings related to each impairment. The report should also mention the need for additional data or the disparate findings. A summary list of impairment estimates and the estimate of the whole person impairment percent should also be included. The evaluator should explain the impact of the medical conditions on the patient's life activities and explain the medical basis for concluding that the condition and the symptoms have or have not become stable. That is, the condition is or is not a permanent impairment or incapacitation as a result of his condition, particularly by engaging in activities of daily living or others necessary to meet personal, social, and occupational demands. A great likelihood of such incapacitation indicates the condition may not be a stable one, that is, a permanent impairment. If accommodations are necessary, the reasons to justify them should also be described in the final report. All this information will be most helpful should the guide's physician ultimately be called for a deposition or to testify in court. Some of the contents of the guides may seem somewhat complex and difficult to implement. In actual practice, however, most cases are reasonably straightforward and present little difficulty to reach a valid estimate of permanent impairment. Before moving on to a discussion of hearing loss, I would like to discuss in some detail the topic of preparing reports. The guides clearly states that a clear, accurate, and complete report is essential to support a rating of permanent impairment. A complete report is also essential if the rater is to give credible testimony and be able to effectively withstand cross-examination. A complete report needs to contain the following: 1. A medical evaluation. 2. An analysis of the medical findings. And 3. A comparison of the results of the analysis with the impairment criteria. A proper medical evaluation has 5 elements. These are a narrative history of the medical conditions, the results of the most recent clinical evaluation, an assessment of current clinical status with a statement of plans for future treatment, rehabilitation and reevaluation, diagnosis and clinical impressions, and the expected date of full or partial recovery. A proper analysis of the medical findings, likewise, has 5 elements. These in turn are: 1, an explanation of the impact of the medical condition on life activities; 2, the medical basis for concluding that the patient's symptoms have or have not become stable; 3, an explanation of why the individual is or is not likely to suffer sudden, subtle, or other incapacitation as a result of the change in the conditions; and 4, an explanation of why the individual is or is not likely to suffer harm or injury by engaging in activities of daily living or other activities necessary to meet personal, social, and occupational demands; and finally, 5, any conclusions as to whether restrictions or accommodations are warranted. Finally, a proper comparison of the results of the analysis with the impairment criteria has 3 elements. These are: first, a description of the clinical findings related to each impairment; second, an explanation of each impairment value with reference to the applicable guides criteria; and lastly, a summary list of impairment estimates in percents. Physicians should use the information on pages 10 to 12 of the guides and the included forms as a checklist to make sure his or her report is complete. This chart outlines how to obtain comprehensive information on which to base your judgment. Some of this may not seem to be pertinent, but bear in mind, if you are called to testify in this case, you may find all the information helpful, especially on cross-examination. Let's focus attention on how to evaluate claims for occupational hearing loss. I will present 2 hearing loss examples. These are illustrative of many of the points I have been discussing. Occupational hearing loss has become the #1 medical, legal, and environmental problem in the United States, chiefly because of the federal OSHA noise regulation and hearing conservation amendment. There are now several 100,000 claims for occupational hearing loss in this country. Many of these claims are presented to general practitioners or otolaryngologists, through industry, workers' compensation boards, insurance companies, or attorneys. The typical complaint of an individual is that he or she works in a very noisy environment, has developed hearing loss, and is instituting a claim for compensation. Occupational hearing loss is compensable under federal law and the law of all 50 states. In shipbuilding, occupational hearing loss comes under the Maritime Law, or Jones Act. In the railroads, claims come under FELA, which stands for the Federal Employment Liability Act. It is now common practice for physicians to obtain a brief history, perform a hearing test and ear examination, which is generally normal, and then write a report that the patient has high-frequency nerve deafness due to the noisy environment in which he or she works. Sometimes physicians add that the patient's job should be changed, or that he or she should wear more effective ear protectors, or should no longer work around noise. Thousands of such reports have been submitted to workers' compensation boards and have appeared in claim reports. Such minimal examinations and reports are often not valid and not in keeping with the recommendations in the guides. As a result, the information that reaches judges, referees, and lawyers could be of questionable reliability and validity. A physician who relies only on his patient's evaluation and working in very loud noise could be misled. The employee's estimate of what is very loud noise and the amount of noise considered hazardous according to the OSHA noise regulation may differ widely. Some employees believe that working in a room with 20 typewriters can cause hearing loss. Others feel computers are causing their hearing losses. Unless a physician has accurate measurements of the employee's job noise exposure, the physician must be very careful about correlating hearing loss and noise exposure. The Federal Occupational Safety and Health Administration, OSHA, has stipulated that noise below 90 dBA time-weighted average, which means exposure 8 hours a day for many months and years, does not cause significant hearing loss. OSHA also points out that hearing testing should be done by industries at 85 dBA exposure, but real hearing conservation does not have to be started until 90 dBA exposure over a lifetime, not just a matter of days. Physicians are obligated to have a reasonably accurate estimate of the time-weighted average of exposure. If we do not have it, we should be careful before we state that the individual's occupational noise exposure was the cause of his hearing loss. There are over 75 different causes of hearing loss, and it is difficult to rule out almost every one without extensive evaluation and expertise. Furthermore, there are over 40 million Americans with hearing losses, not due to their occupation. The American College of Occupational Medicine has even published some criteria to help physicians determine the specific diagnosis of occupational hearing loss. Let's comment on several of them that are discussed in the following slides. Noise exposure, especially occupational noise, damages the cochlear hair cells, not the middle ear or auditory neurons for the most part. It is the outer hair cells that are damaged initially. This explains why the discrimination ability scores are not markedly reduced, since the outer hair cells convey only about 5% of information to the brain. The patient must have been exposed to sufficient noise above 90 dB for a long enough time to have caused the hearing loss. The hearing loss is always sensory neural. It is generally bilateral, affecting both ears equally or almost equally. The earliest damage occurs in the 3,000 to 4,000 hertz area. Occupational hearing loss occurs in the first few years of exposure and reaches a maximum in some 10 to 15 years. Occupational hearing loss does not continue to progress when the employee stops being exposed to noise or puts on effective ear protectors. The hearing loss is rarely greater than 40 decibels in the lower frequencies and 70 dB in the higher ones. Now let's look at two actual hearing loss claims sent to an otologist by a company's attorney requesting the answers to the following questions. Does the employee have a hearing loss? Was it caused by his job at the company? Is it compensable? And can he continue his work? Is the loss correctable? And does he need a hearing aid? The information sent to the otologist included job history, noise measurements, annual audiograms, medical history, and depositions from the employee and his expert witness. The independent medical examination by the otologist confirmed that this 45-year-old employee's history and findings were valid and consistent. He worked 15 years using a jackhammer, almost daily, but intermittently. He did not use ear protectors until 3 years ago, and noted the gradual onset of hearing loss for about the past 8 or 9 years. He did not have tinnitus or vertigo, and he was in good health. He denied any gun shooting experience. Most other causes that might contribute to his hearing loss were ruled out by the extensive history. His time-weighted average of noise exposure was about 93 dBA, which is above the level considered safe by OSHA. The 10 years of serial audiograms from the company showed consistent thresholds that gradually diminished during the last 5 or 6 years, especially in the high frequencies. The audiologic findings are shown here. The frequencies tested are from 500 to 8,000 hertz, and the patient's threshold at each frequency in terms of decibels. The frequencies at 500 to 3,000 hertz are considered the speech frequency range, required for hearing satisfactorily in everyday communication. The greater the decibel number, the louder the tone has to be for him to hear it. Between 0 and 25 decibels is considered within the normal range of hearing. If a patient's threshold of hearing exceeds an average of 25 decibels in the speech frequencies, he has increasing hearing impairment. To obtain the impairment rating, we add the thresholds at 500, 1,000, 2,000, and 3,000 hertz in each ear, which happens to come out to 85 decibels in each ear. We then use Table 1 on page 225 to get the monaural hearing impairment rating, and Table 2 on page 226 to get the binaural impairment rating. Since the total in each ear is less than 100, and the average is 25 dB or less in each ear, then there is no disability present, and the hearing loss is generally not considered compensable. This is evident in the chart on page 226 that starts at 100 decibels, indicating that nothing below a total of 100 decibels can be considered handicapping when adding up the thresholds in the 4 speech frequencies. The final report should explain that the patient has a non-reversible bilateral high-frequency sensory neural hearing loss due to the noise on the job, but he has good hearing in the speech frequencies. The normal speech reception and normal discrimination scores mean he can get along very well in everyday communication, and therefore that he has no disability or handicap. He can continue to do his work and should comply with the company's hearing conservation program, especially about the use of ear protectors. Now let's look at another actual hearing loss claim of a 62-year-old man who was a mechanic for 30 years in a noisy metal shop. His time-weighted average of noise exposure was 98 dBA. The main features of his history revealed gradual onset of hearing loss for over 20 years, without much worsening during the past 10 years. This table shows his serial audiograms from 1972 to 1987. He did seasonal hunting, he's in good health, and denies hearing loss in his family. He's been using hearing protection for the last 8 years of employment. He retired in 1988. His audiologic status is described in this following chart. As you can see, the impairment is 16% impairment. His diagnosis is occupational hearing loss, and he should use at least one hearing aid, but he can continue his work as he has for so many years. The question arises frequently: why frequencies above 3,000 hertz are not included in assessing impairment, especially since noise damages these frequencies first and to a greater degree. Also questioned is why no compensation is recommended for hearing losses below 25 decibels in the speech frequencies or even in the higher frequencies. The answers to both of these questions were established by a superb research study done in Pittsburgh in 1960 by Nett, Derfler, and Matthews. The study took many years to perform and was done by numerous experts who investigated the relationship between audiologic measurement and handicap. In their extensive report, they concluded that if an individual's hearing is 25 dB or better, averaging the thresholds at 500, 1,000, and 2,000 cycles, he or she does not experience any significant hearing handicap or disability in his daily living, occupationally, or socially. The validity of this study has never been scientifically repudiated. The AMA formula uses this 25 decibels as a so-called low fence and assumes that the hearing loss is also present in the higher frequencies. It has also taken into consideration the presence of presbycusis. To explain the fairness of the AMA formula, we must recall that people generally speak at levels well over 60 dB, and in a noisy environment, they speak much louder than the levels of the noise around them. Even a whisper can be over 40 decibels. While it is often stated that vowels fall into the lower frequency range and consonants in the higher ones, enough information from the consonants falls into the 1000 and 2000 hertz frequency range to make them discernible, especially when sentences are used so that people with severe hearing losses above 3000 hertz frequently get over 92% discrimination scores using single words in a quiet room. In a noisy environment, these and even people with normal hearing do not discriminate as well. But we must recall that in general communication, we use sentences, not single difficult words, and this enhances our discrimination with even the most difficult sounds. This study shows that frequencies above 3000 hertz can be helpful, but not essential for everyday hearing, especially in the vast majority of occupational situations. A helpful feature to remember is that telephone receivers generally cut off at about 2600 hertz and give little response above this, and we can still hear and understand quite well on the phone. Occupational physicians who are familiar with job requirements can, in the final report, describe any limitations, prognosis, handicaps, and social and other difficulties an employee might encounter. Many physicians can additionally elaborate on disability and handicap to help in claims and litigation. In evaluating case reports, we must be especially alert to obtain reliable and valid histories and findings about the impairment, not only from the employee's history, but from employment records and all previous employment examinations and information. Conjectures and speculations should be avoided as much as possible, particularly for railroad workers for whom all cases go before a jury or judge. We should also have some familiarity with claims for workers' compensation. Such claims by an employee generally are governed by each state's workers' compensation statute and regulations. Each state writes its own laws, and they differ considerably among states. If he or she is employed in the shipbuilding industry, the claim generally falls under the Maritime Law and Jones Act, and this differs from most of the workers' compensation state laws. If an employee works in the railroad industry, the claim falls into the FELA category, a completely different workers' compensation law. In general, the state and federal workers' compensation laws, with the exception of the FELA, are based on the concept that a worker who sustains an injury or illness because of his job is entitled to protection against financial loss without having to sue his or her employer. In exchange for the workers having lost his right to sue, the state workers' compensation system guarantees certain benefits to employees. Under state workers' compensation claims, the employee presents, either directly or through a lawyer, to a claim commission all of the information about his or her injury or illness and why he or she should be compensated under the state workers' compensation law. Information provided by physicians is most essential for this decision process. Each commissioner or hearing official, not the physician, must come to a conclusion based on the available medical and non-medical information about the presence of impairment, disability, and handicap, and then decide on the amount and type of compensation to be awarded to the employee. One of the critical problems confronting the hearing commissioner is that no single formula is known by which a medical condition can be combined with other factors to calculate the percentage by which the worker's use of his body in working is impaired or disabled. Accordingly, the commissioner or hearing official must come to a conclusion on the basis of available medical and non-medical information. The guides can help resolve such situations, but it does not in every instance provide a complete and definitive answer. If a payment to the employee is approved, his remuneration can fall into three categories. Number one, payment for lost wages due to temporary total disability. Two, payment of medical bills. And finally, payment of an award for permanent, partial, or total disability. Disability, whether temporary or permanent, is equivalent to economic loss for which the individual is to be compensated. Temporary partial disability occurs when the employee with the impairment returns to work but earns less than before. Normally, permanent disability associated with a permanent medical impairment is independent of an employee's capacity to work and is formulated in terms of expected long-term economic loss. Usually, there is a schedule in most of the state workers' compensation laws that equates the disability with a maximum number of weeks for which benefits are to be paid at a rate based on average weekly wages. Hearing commissioners can make a more equitable decision if the physician provides them with more than a number or percentage. A comprehensive medical picture of the patient's status using the report of medical evaluation as an outline is extremely important. This will enable the hearing official to coordinate the medical information and the non-medical information and to understand how the impairment may affect a patient's employability and daily activities, and especially whether the disability is permanent or temporary. The more valid information physicians provide to the claims officials, the more equitable and reasonable the judgments will be. If an employee works for a railroad company, the employee does not fall under state workers' compensation regulations. In 1908, Congress provided that railroad workers should have a special type of compensation, and a Federal Employers' Liability Act, abbreviated FELA, was passed to cover their compensation system. This is an exclusive remedy for injured railroad workers, and it supersedes the state workers' compensation law. If a lawsuit occurs under FELA, it must be based on the negligence of the railroad and failure to provide the employee with a safe workplace. The evidence is generally presented to a judge and jury by attorneys representing each of the sides. It is the employee's responsibility to prove that the railroad should have foreseen the condition that might have caused injury or disease. Under FELA, the verdict of the jury can include medical expenses, expenses for pain and suffering, loss of past earnings, and future losses due to diminished earning capacity. But under FELA, it is stipulated that the effects of the injury must be diagnosed by a physician. Of utmost importance is that there are no limits to the amounts of the awards. And in general, many of the safeguards for both sides that are found in workers' compensation cases are not present under FELA. In many instances, compensation claims can be adjudicated not only by judges and juries, but also by referees, commissioners, claims administrators, Social Security personnel, U.S. Department of Veterans Affairs, and some insurance companies. Most of the individuals making these decisions have specialized training in evaluating and deciding claims. In some instances, the claims can be evaluated by one or more arbitrators who also have special training. The credibility of claims would increase if the information in the guides were used properly to substantiate the claims. I will now take a few minutes to discuss employability. More and more frequently, Physicians are called upon to determine whether an individual can be employed or should be allowed to continue his job. This issue has become so important that the federal government has passed the Americans with Disabilities Act, abbreviated ADA, as a guideline for employability. It is essential that physicians become familiar with the ADA regulations as well as the needs of employees in industry. In this matter, we bear chief responsibility for the health not only of employees, but of industry and the country as well. Under the issue of employability comes the added responsibility of physicians to prevent workers' injuries and diseases. By recommending employability for an individual who is likely to become injured or disabled when such a probability is predictable and preventable, we severely threaten the employee and the company and may add to the enormous costs for health care. Physicians have the responsibility of lowering health care costs by emphasizing the prevention of unintended injury and disease. Employability of an individual is strictly related to his capacity to travel to and from work, to be at work, and to perform assigned tasks and duties for which he is to be paid wages. If an individual can perform these tasks, even though he may be impaired, he or she cannot be considered disabled. The emphasis on hiring the handicapped and increasing the ability of an individual with impairments and disability to continue work should receive sensitive and sympathetic attention from physicians. While determining the employability of an individual with impairments, it is essential to establish his or her status as a safety risk to himself or other employees. The physician who has to make such a determination must become familiar with the job the employee has to do, including the employer's expectations with respect to performance, physical activity, reliability, availability, productivity, expected duration of useful service, and any other important requirements of the job. The employer must provide this information for pre-employment determination and the ability of the employee to continue his work with respect to the job's demands. When assessing an individual's employability, we must bear in mind the potential for aggravation of an impairment and the possibility of an individual's job and responsibilities being changed. The physician must be certain that the clinical findings and history that he is evaluating are reliable and valid. When different physicians employ the guides to reach their judgments, the results can be favorably compared to the employability determination and generally become independent of the individual's motivation to work. Frequently, physicians are referred patients from local industry because the employee has been injured or has experienced some illness. Experience has shown, unfortunately, that in many instances, physicians help patients to take an extraordinary amount of time off from work and thus aggravate the ramification of the condition. Every effort must be made for the physician to be sensitive not only to the patient's needs, but to the industry needs as well. When the patient is not at work, the employer has to find a replacement for his job or stop the job's production completely. In addition to this, unnecessary testing must be avoided to contain health costs, reduce time off from work, and treat the patient effectively. Physicians play an increasingly important role in reducing health costs and improving the cost effectiveness and productivity of American employees. Finally, I'd like to take a few minutes to answer some questions concerning the guides. I trust you find these questions and answers to be helpful. What should the rating physician do if the medical opinion reports in front of him, one from the defense and one from the claimant, are in conflict regarding diagnosis? He should evaluate and compare the findings on which each expert based his opinion. If the findings differ and the reasons are not obvious, another independent examination may be necessary. If the interpretation of the same findings differs widely, you have to decide which is more valid or also get another expert opinion. Now, what are the important differences between occupational hearing loss and hearing loss from gun shooting or diabetes? Occupational hearing loss develops insidiously from habitual exposure to noise over many months and years and has specific characteristics that I described. It also has many other characteristics. Gun shooting is generally much louder than occupational noise and causes more hearing loss in the left ear if you shoot right-handed because the left ear is very close to where the bullet explodes. The hearing loss rarely extends into the speech with most gun shooters. Diabetes can produce high and low frequency hearing losses, generally due to vascular damage, and the audiologic picture can simulate noise-induced hearing loss, but it can also affect only one ear or produce a much different audiologic picture. How do the guides deal with the term normal? The answer is found on page 2 of the guides. The guides recognizes that normal is not a fine point or an absolute. Normal is a range or a zone and can vary with age, sex, and other factors. Are all impaired individuals disabled? Page 2 of the guide states that disability depends upon the job and the individual. An individual who is able to meet life's demands is not disabled, even if he or she has impairment. Now, when can the physician round off the final impairment rating? Final estimated whole person impairment percent may be rounded off to the nearer of the nearest values ending in 0 or 5. This rule is provided on page 9. Should the physician have the individual use his or her prosthesis or assistive device during testing? The guides on page 9 states that generally, if the prosthesis or device can be removed easily, the organ system should be tested and evaluated without the device. How do the guides deal with rating impairment for a patient who declines a surgical procedure, pharmacologic agent, or other therapeutic approach? Page 9 of the guides provides that the decision to decline treatment should neither decrease nor increase the estimated percentage of the patient's impairment. How does the 4th edition of the guides deal with apportionment? For example, in a spine impairment, the physician should first estimate the current spine impairment, then estimate the impairment from any pre-existing spine problem, then subtract the estimate from the pre-existing impairment from the present impairment. What should the physician do if his or her findings are not consistent with the results of previous clinical study? In this situation, the guides provides on page 3 that there should be communication between the involved physicians as needed to resolve any disparities. What documents should be attached to the evaluation report? Where possible, copies of existing medical office and hospital records should be attached to the evaluation report as provided on page 8 of the guides. Now, what are the 3 steps a physician is to utilize in assessing an individual's impairment? First, the physician must gather a complete medical history and carry out a medical evaluation. Second, the physician must analyze the history and the clinical laboratory findings. Lastly, the physician must compare the results of the analysis with the criteria specified in the guides. What should the physician do if he or she believes that the patient has an unrelated condition and that the extent of each should be estimated. In this situation, the guides commands that the whole person impairment estimates would be combined into an overall impairment estimate by using the combined values chart. When and how should the physician modify an impairment estimate? The guides allows modification of impairment estimates when, in spite of an observation or test result, the medical evidence appears not to be of sufficient weight to verify that an impairment of a certain magnitude exists. When can an impairment value be interpolated? The answer to this question is found on page 9 of the guides. When an impairment value falls between those appearing in a table or figure in the guides, it may be interpolated to the interval of the table or figure involved. That concludes my presentation, and I sincerely hope you find this tape to be useful. Thank you.